My people, Amebo Barrister don't come again. When I remember the story of our friend Moses, the upcoming artist. Update don't drop. Moses no gree for the record label people. Him saying no fit gree for that kind of arrangement. When I go they sing, the record label they collect 85% of the money. According to Moses, this one a monkey they walk, baboon na in the chop. Now Moses on his own don't begin to do private performance. They leave the record label for back, they gree carry them along again. But no forget say Moses and the record label be don't get agreement with them sign. And this agreement then they call contract. And this one where Moses they do now, we contract today, Moses they follow backyard, go do work. And we they call breach of contract. So now make we carry leg put for inside the matter of a breach of contract and failure of party to perform duties under the terms of the contract. As we discussed earlier, a contract is an agreement between two or more parties, spelling out the duties, responsibilities, and privileges of the parties in that agreement. And it also goes on to state what will happen where either party fails to carry out his or her responsibility under the contract. Where a party to a contract fails to abide by the terms of the contract, it is referred to as a breach of contract. There are different kinds of breaches when it comes to contract. We have material, fundamental, and also anticipatory, to mention just a few. Common examples of breach of contract include failure to supply goods within anticipated time. It can also include failure to carry out responsibility or do an action, as in the case of our friend Moses. So when you and record label don't get agreement on how una go to do the performance, Moses on his own waka backyard go do one thing by himself. My brother, that is a breach of contract. Now, what happens when a party fails to perform his duties and responsibilities as spelled out in the terms of the contract? In such a circumstance, there are a number of options available to the other party to the contract. They may choose to enforce specific performance against the defaulting party, they might choose to go for damages, or they might even seek complete termination of the contract in its entirety. It all depends on the nature and circumstances of the breach, as well as the demeanor of the parties in the entire matter. It is crucial for all the parties to know their rights and responsibilities when entering into a contract, because not only do they have a right and responsibility to abide by those duties, but that they can also be found liable in the event that they fail to perform the said duties, thus amounting to a breach of contract. A proper understanding of the terms of the contract helps to prevent all manners of disputes and in all reduce the chances of a breach of contract, while at the same time ensuring a smooth business relationship between the parties. So whether you are a business person or just a random legal enthusiast who is interested in knowing a thing or two about the workings of contract, knowledge of terms of contracts and the breach thereof is a fundamental one which you must have at your fingertips. So now to our friend Moses, we know say the agreement, it be like he say e no good. But my brother, remember wetin we talked before? Agreement is agreement. Shey na you carry your hand sign the paper. You must stand gidigba like the rock of Gibraltar that cannot be removed until you take steps to set aside the contract or revoke it one way or the other, or even trying to amend the terms of the contract. My brother, you no get option o. That thing where you do, where you go perform for backyard without the record label to know wetin you dey do. It is a breach of contract and you can be held liable in law.